Hello, how are you today? This is Bong Soo-jung, Korean labor attorney. Today I'd like to talk about company's dissolution due to the business deterioration and workers' right in that situation. Based on actual labor case, I'd like to explain about that issue about labor law, how to protect the workers' right. So the one fitness club under this building where my labor law firm is located, they decide to close their business because they suffered from long time the reduced service because of the reduced membership influenced by the COVID pandemic. So they could not pay rental fee for the past 6 months. So there are about 30 workers working in this fitness club. So they were informed about just 1 month's notice for their termination. Also, the company announced anybody who signed the resignation agreement, then company will pay 30 months additional salary, including severance pay. So some employee representative visited this labor law firm and asked what is a good solution to ask for some better the benefit or better payment from company. So I start to think of that issue and advise them what is their right and what they cannot do. So even they asked about establishment of labor union. So in this last moment, so there was no labor union so far. So my answer was that the Article 23 of the Labor Standards Act, so employer cannot dismiss employee without justifiable cause. So in this case, when company decide to close their business, this is a justifiable cause for the terminating employment relation with their own workers. So only their duty to do is according to the 26th of the labor article 26, so 30 days early notice or 30 days advanced allowance, like notice allowance for 30 days. That is all they can have. So but they can request some the unpaid unused the annual leave allowances. So, but the other, if there is unpaid the allowance for overtime or other allowance, they can ask. But about the establishing labor union and request collectively for some collective bargaining. So in this case, 1 month period is too short. So even though they establish labor union, maybe they can establish a labor union within 30 days. But important is union can be protected based on collective agreement. So if employer neglect to agree on certain condition, then their termination is decided in 1 month. Then how they can protect themselves? So in this situation, it's better to accept that termination letter and signing and receiving 30 months additional salary for this situation. So if the unpaid wage is more than 3 months, then it's better for them to take legal action. So that is all I could explain to them. It was a very sad story. So in this situation, I felt strongly necessity of labor union. If they had a labor union, they must have some collective agreement. In this situation, they had secured something how company should compensate in the case where the company decide to close their business. So I think in peacetime, it's required for workers to establish labor union to prepare in worst situation. That's something I learned in this dissolution case of the company. Okay, this is all. Thank you for watching. Bye bye.